Hi, this is Attorney John Roach. I want to talk to you a little bit about preparing a traumatic brain injury plaintiff for a deposition. And I'm talking in this video about mild traumatic brain injuries. In severe brain injury cases, my advice would be to prepare your client very little, make them very comfortable in the process, but essentially their brain injury is going to be Exhibit A in the deposition. But for people that do a lot of mild traumatic brain injury cases, which would essentially be a concussion with lingering effects that don't go away, I have 3 tips. Number 1, have your client evaluated by a good neuropsychologist before your client's deposition. This will serve the purpose of educating your client about some of the deficits that the neuropsychologist finds important that will play a role in the case further down the line. Number 2, prepare your client. Spend 2 or 3 sessions developing your client's story so that when you get to the questions about how it impacts their life, they're ready to tell their story. Number 3, when your client's asked whether they suffered a loss of consciousness in the collision, you need to educate your client about why asking a brain injured person whether she or he lost consciousness, well, that's the worst person to ask because they often don't know. So I would talk to your clients about whether they had a brief lapse in memory during the time following the impact to the head and their next memory. Often we see in mild traumatic brain injury cases, emergency room reports saying no loss of consciousness. And when we dig a little deeper into it, that may not be the case. However, what's really important in a mild traumatic brain injury case is that there's something called altered consciousness. So if your client saw stars or had other manifestations of not being in her or his right mind, you want to elicit that in the conversations leading up to the deposition. So those are my 3 tips. Thank you.